Ladies and gentlemen, dear colleagues and friends of the Käte Hamburger Center for Advanced Study in the Humanities, Law as Culture. It is a great pleasure for me today to give the opening of this year's Forums evening, featuring my colleague and co-director Werner Gephart's presentation from natural law to cultural law. Since its establishment, the Käte Hamburger Center in Bonn has dedicated itself to contribute to an understanding of law at a time when the globalization, the world's normative order, have been becoming subject to this progressing globalization. In this endeavor, the center has focused on 4 thematic pillars over the past years. The first having been law and religion as 2 paramount and often competing normative orders. Secondly, we concentrated on law and the process of globalization, which not only brings normative cultures closer together, but in the ensuing legal pluralism also leads to clashes of legal culture. Those tensions or conflicts of legal cultures constituted the third thematic pillar, followed by an examination of the many forms of legal representation in literature, film, and architecture. In the upcoming research year, we wish to bring together the research insights gained before under the title Law as Culture, or In the Name of Culture. As in the process of globalization, societies have become religiously and culturally much more diverse, the question arises to what extent culture can be invoked as a claim in the legal order, or validity may be grounded on culture. In many countries nowadays, religious and cultural norms compete with legal norms, seek recognition in the legal sphere, and may prove a challenge to a universalistic concept of law, in particular in the area of human rights law. Lately, with rising numbers of immigrants and refugees from various cultural, religious, and legal backgrounds coming to Europe and Germany, these questions will become all the more relevant and will have to be dealt with from a multidisciplinary perspective, something that we endeavor here to undertake at our center. Before I give the floor to Werner Gephart for his talk, there remains one important and also very pleasant task for me. Ladies and gentlemen, what are the essentials of our endeavor at the center here? Not only projects, but people. I would therefore like to welcome the people who have come to join us here this year. Above all, we are very pleased that our colleague Professor Clemens Albrecht has joined us as co-director at our center. He has only very recently accepted his nomination for chair of sociology at the University of Bonn and has not even started his work at the faculty. We are thus very happy that he has already joined our directorate at the center and are looking forward to our joint work. Unfortunately, he could not make it tonight due to another urgent obligation. He's not yet here fully in Bonn. Moreover, it is a pleasure to welcome Professor Martha Buchholz. Where is she? There. Thank you. She has just been appointed as a research professor for sociology and has taken up her work here at the center as of September this year. Martha Buchholz brings with her the perfect background for our center. Having studied sociology, philosophy, and law at the University of Warsaw, where she obtained a doctoral degree in sociology and subsequently worked as an assistant professor for sociology. Just last week, Martha Buchholz has received the prestigious, and I do hope that I will pronounce this correctly, Polacy i Werwa Prize for Young Polish Researchers, which was awarded during a gala ceremony in the Grand Theatre, opened by Lech Wałęsa. Congratulations to you. As I said, the people here are vital for our interdisciplinary and intercultural exchange. At the heart of our center is the community of fellows from a variety of disciplines coming from all over the world. They spend any time between 3 months and 1 year at our center, pursue their own research projects which are related to the general topic of the current theme, and participate in all our activities. October is usually the time when new fellows arrive. The first one I would like to welcome is Professor Daniela Bifulco. Yes, thank you. She's a legal scholar from the University of Napoli, where she teaches comparative public law. In her research project, she's pursuing the question, religion as a new source of law. Welcome to our center. Secondly, I would like to greet Professor Judith Hahn from the University of Bochum, where she is a professor for canon law at the Faculty of Catholic Theology. Her topic is Church Law and Modernity, Canonistic Validity Theory between Legal and Cultural Plurality and Theonomic Universalism. We are glad to have you here with us. Our third new fellow is Professor Moussa Samb. Moussa Samb is a legal scholar from Senegal, yes, thank you, where he's a professor of private law and business law at the University Cheikh Anta Diop in Dakar. He's going to work on the resurgence of mediation as method of alternative dispute resolution for social conflicts in Africa. Welcome to you too. Last but not least, I'm very glad to introduce Professor Erika de Wet. She's a legal scholar from South Africa. Erika de Wet is professor for international law and co-director at the Institute for International and Comparative Law in Africa, South Africa at the University of Pretoria. Since 2015, she's also honorary professor at the University of Bonn, an honor that is very seldom conveyed. Her research topic at our center is customary public international law and human rights, the tension between state practice and legal culture. It is a great pleasure to have you all with us here, and a very warm welcome to all of you. Ladies and gentlemen, contrary to our usual practice, there is no need to introduce tonight's speaker, Werner Gephart, founder and spiritus rector of this wonderful center. The floor is all yours.
Thank you very much, Nina, as I had to say in the English-speaking world, though in German faculties it may take decades until such an audacious kind of word could ever be pronounced among colleagues, but I do it with the greatest pleasure. Dear friends and supporters of the Käte Hamburger Kolleg Law as Culture, liebe Freunde des kanonischen Rechts und insbesondere Judith Hahn als neuer Fellow, ainsi que mon cher collègue et juriste Moussa Samb du Sénégal. Assez loin de Bochum, d'où vient Madame Hahn, comme vous avez dit, Signora Daniela Bifulco, da Napoli, giurista e constituzionalista, and Erika de Wet, specialist in public law from South Africa, as we heard in more detail. Last but not least, Dr. Wächter, who accompanies the center from the side of the project manager. Very welcome to all of you, also from my side. As you have seen, to have a geschäftsführende Direktorin aside will make my work much easier, being able to concentrate even more on the thematical focuses of the center in the future, as I hope. Let me start with a look back to 5 years of law as culture. It's a little bit later. Of law as culture emerging in the formulation of a law as culture paradigm that may be used for multiple purposes. as comparing legal cultures and reflecting legal reasoning in different cultural and social contexts, for example. In the second step, I would like to develop some ideas about culture as an argument in legal discourse, in order to situate this questioning in the larger context of the debate about natural law arguments and cultural-related topoi, tentatively at least in penal law, family law, and constitutional law, a big project for some centuries. I want to conclude with more general reflections of the sociological critique of natural law. The sociologists claim to find in society itself the solution to the normative problem. The legal historian's assumption that history would produce a relatively rightful natural law, or to lay all normative power into the procedure itself, finally to ask where the reference to culture as a primary source of normative validity may lead to. This will be the conclusion. Looking back to 5 years of law as culture, my first point. The most important insight gained was that the thematic sequencing of law as culture into precisely 6 research years by no means gave rise to artificial breaks in the process of thought development. On the contrary, it proved both a fruitful and practical basic guideline for diverse disciplines that, with a varying radius and rhythm, routinely moved beyond the supposed European center. And this is a very fundamental point for the self-understanding of this institution, to go just really beyond into India, Asian countries, also the Arabic Islamic world, and with Musa Sam also to the African continent, including the region of the Israeli-Palestine conflict and so forth. Whereas the opening symposium was conceived as an overview over these topics, subsequent years highlighted individual thematic focal points. The concept of law in global world, the first year, you talked about 4 points, 4 years. So for me, it's also a little bit interesting to see what the concept of law may be in a context where the debates in legal theory very often lead to a point to say, no go, we won't any longer talk about the concept of law at all because there had been too much debate. I think the way we try to open and reopen the debate, and I will come back to this point, may be interesting for some of you. The constitutive relationship of law and religion you were mentioning, law in the context of globalization and the problem of encounters and conflicts between legal cultures, as well as the relationship between law and other cultural phenomena, particularly literature, the visual arts, the media, architecture, etc. That said, we did pay particular attention to the transformation of law in the context of the Arab Spring, as part of our research question, observing the local and translocal normative upheaval that began in Tunisia in December 2010. This was an example of a process that was being registered worldwide in which, under pressure from the Arab street, so to say, purportedly secular authoritarian regimes subscribed to the slogan of freedom, dignity and justice. They thereby ushered in revolutionary upheaval, the consequences of which were by no means clear at the time. That the newfound communicative freedom also applied to Islamist forces and their references to Sharia was not surprising, and yet it was not foreseeable how deep the division of these societies along a secular religious fault line would run. This thematic emphasis was also reflected in the selection of fellows. Hamadi Redisi, Sami Bustanji, Elizabeth Kassab, Asma Nouira, and last but not least, Sadiq Al-Azm, who was awarded with the Goethe Medal in Weimar this summer. This is a rather rare experience in life, and it was very pleasurable for him as a fellow. And one can continue as well in the organization of a series of forum lectures, but also several larger events. The first conference on processes of transition in the Arabic Islamic world was organized by the Center in the university's Festsaal in April 2011. The conference on the reference to Sharia was held in the following year, 2012, and our last conference in Tunis in February this year was devoted to the problematic of droit et culture en transition at Beit el-Hekma in Tunis. And this resulted in a reflection and was condensated in the last book of our series under the title Rechtskulturen im Übergang, Legal Cultures in Transition, as we have named our last publication. So much the more, we feel very proud that our main focus of a reconciliation of a secular and a religiously oriented validity culture has found a kind of indirect recognition by the Nobel Prize Committee to honor the historical moment when the process of transition to a democratic political system and a correspondent legal culture was in its greatest danger. So I read from the Prize Committee. The Norwegian Nobel Committee has decided that the Nobel Peace Prize for 2015 is to be awarded to the Tunisian National Dialogue Quartet for its decisive contribution to the building of a pluralistic democracy in Tunisia in the wake of the Jasmine Revolution of 2011. The quartet established an alternative peaceful political process at a time when the country was on the brink of civil war. It was thus instrumental in enabling Tunisia in the space of a few years to establish a constitutional system of government guaranteeing fundamental rights for the entire population, irrespective of gender, political conviction, or religious belief. And so in a way you may understand that we were proud that we followed up this movement and this process from the beginning on. And we have been in touch with the people who got the prize for a longer time. The greatest challenge during our voyage through the land of normativity was keeping the various strands of the discussion together. To depart from a broader definition of law as well as from its sacral dimension in order to recognize law as a transnational judeoscape, so to say, in terms of Apandourai, while also paying attention to the forms of representation and performance of law. So the institution of the artist in residence, who our current artist in residence is unfortunately not present, but with Alexander Polsin, with Ali Samadi Ahadi, the Simul Artist stipend became really very colorful, and especially, I think, with wonderful talks we could have with Tim Shaw, who is a speaking artist, and not only a painting and a sculpturing, but he had brought in a lot of discussions and questions of how to conceive what deontic power is on canvas and also in the text of the law. We therefore seem to have been successful in not only bringing different knowledge cultures together in one location, but also providing a source of inspiration and interaction beyond the fault lines of law and cultural science and reflexive aesthetic practice. We consider our center's distinguishing feature to be how it brings up questions of daily life in a global world from diverse perspectives, as globalization theory pioneer and fellow at the Käte Hamburger Center Law as Culture Martin Albro reminded us in his newly published book. The controversial circumcision decision by the District Court of Cologne, for instance, dramatically highlighted a conflict between the secular protection of physical integrity, the violation of which carries criminal law sanctions, and the claims of two confessional cultures to define their collective identity through precisely this incriminated act. The question forming the premise of the Center's research has thus been validated. How can a normative commitment be created under the conditions of globalization and the rediscovery of religions, in which the plurality of normative projections are linked together as an agreeable multiple order without constructing a new uniform law of normativity or lending a validity to the particular special realms that would result in the dissolution of normativity itself? That's the riddle we try to solve. In order to grasp this problem statement theoretically, one should add that we were not only concerned with philosophy of law and sociology of law, but to a certain extent also with John Searle's concept of deontic power, which provides a link to the debate on force du droit in the work of Benjamin and Bourdieu. The development of the law as culture paradigm in the work thus emerges as a central result of the first project phase, a paradigm in which law is questioned as to its non-normative preconditions in interplay with the legal and cultural science disciplines that are challenged and inspired by aesthetic practice. Law as culture is also about the development, probation and consolidation of a frame of orientation and reference that we call the law as culture paradigm. This paradigm has developed as follows throughout the course of the first project phase. The first problematic led to the fruitful and new insight that a multidimensional concept of law can lead away from the limitations of a purely juridical and occidental self-description as an order of norms. Such a concept expands traditional notions by identifying a symbolic dimension of law as the vicarious sign of representations and appeals to what is seen as right and just, the restraint of the effervescent forces of rage and revenge through the ritualization of procedure, and the deontic power of the organization of courts and the legal community. Our Durkheim conference in 2 weeks will give an opportunity to trace back the roots of this model to Durkheim's concept of social life in general. Did you all receive the invitation cards? So that's fine. The hypothesis formulated in the initial funding proposal that law only attains a concrete form through its counterpart religion, even in modernity, was only strengthened in individual research work and colloquia with, for example, the sections of the German sociological associations and others. Very fundamental debate. If you take only Weber and Durkheim and a lot of other people who think about what holds societies together, what makes them work, and where comes dynamics and statics from, we always come back to the two pillars of the law on the one side and the religion. But they have similarities. They have subjacent relations. They have functional similarities and also sphere relations that very often are rather difficult. Conceiving of the relatively late special historical product of the nation state as the universal production side of law is, as you know, rather naive. But the way in which local, national and transnational normative orders are interwoven, and this will be very interesting for the case of Africa and some kind of African jurisprudency, so to say, and ways to find the legal and the deontic power in order to bring social order into places and locations where sometimes a state of nature seems to prevail. This is a very important debate we will lead during the coming weeks and month in this and at this center. So globalization is one very strong element in this debate, meaning that culture arguments try to gain validity exactly in this problematic, how the different normative orders are related to one and the other, as manners, as state law, as customs, as normative practices, as fashion modes, as morale, and so forth. A related issue is the heightened sensitivity towards clashes of validity between legal orders, but also those orders and powers that we consider to determine the world. This perspective of interwovenness and conflict requires that permanent attention be paid to the observation of legal facts. And we had examples of that. The crucifix judgments, the Cologne circumcision judgment mentioned before, the controversy surrounding a Muslim as champion marksman in a Catholic shooting club fraternity, or most recently the appearance of a self-proclaimed Sharia police in Wuppertal demonstrate how present and relevant this topic is in Germany alone. And it will be more present in the future, and you were mentioning that. The waves of refugees led also refuge for a great amount a respective legal culture that is not identical with the dominant ideas about the legal ordering in society. It is, if it is true that legal cultures do have an impact on the construction of one's own identity, that's one debate we had about the function and the identity producing function of the law. And if it is also true that many refugees will suffer will suffer from traumatizations that affected their self-image, the problem of integrating legal cultures in a well-balanced legal consciousness may increase. A consciousness that gives the right part to the dominant legal order, but leaves in the same time a space for the identity-related conception of right and wrong in the new world. Coming back to the world in move, it is not just Europe and Germany where the refugees movement go, but it is a worldwide tendency. 60 million of people in the world are flying from war, conflicts, persecution, according to the United Nations High Commissioner for Refugees. To make the figure more vivid, if they were added to one nation, they would compose the 24th most populated country. Imagine that. With regard to Germany, some figures may recall your attention. For the whole year until now, we count 577,000 people who have been registered as asylum seekers, not counting the possibly much higher number of non-registered people. There has been a big rise of refugees from Syria and Iraq, with the effect of shifting the relations of religious affiliations in a substantive way. Whereas concrete numbers for 2014 tell us about a proportion of 63% with a Muslim background, current estimations go up to 80%. The probability of certain types of conflicts may thus be increased. Namely, conflicts originating in different or even antagonistic views of the role of religion in a modern society. Equal rights for women and the right of every individual to sexual self-determination, freedom of speech and press. Furthermore, a divergent perception of history, especially in regard to anti-Semitism, can play a role. Some sociologists, like Amin Nassei, have also expressed concerns regarding threats of a masculinization of public spaces, as some of you have always supposed that I'm a hidden feminist. All this creates a necessity for European societies to make strong efforts to include migrants by offering language qualification and working possibilities, and at the same time convey the social norms in question. Another field of tension opens up when looking at a more general legal conflict connected to the influx of refugees, as Sheila Ben Habib puts it. From a normative point of view, transnational migrations bring to the fore the constitutive dilemma at the heart of liberal democracies between sovereign self-determination claims on the one hand and adherence to universal human rights principles on the other. In the question about the freedom of movement versus the democratic right, the question about the freedom of movement versus the democratic right of exclusion. I have my great doubts whether we are able to solve those questions with the pure means of, I forgot this, to show this one, and so we come later on to this point. I have my great doubts whether we are able to solve those questions with the pure means of, and I look at the jurists of, and I say it very consciously, of traditional jurisprudence alone. Instead, a reflected socio-cultural jurisprudence may be necessary in order, may be summed up as follows. So what I simply wanted to say is what is important would be to bring in a multidisciplinary approach to those questions without having a normative solution as such when referring to the history of art or to sociology of law as such, or to, let me say, studies in literature. But that, to bring different disciplines together under the hat of those very fundamental questioning may lead to other and perhaps better solutions. So I come perhaps also to this point, and this might be interesting, that the question of norm conflicts in pluralistic societies that were so important during the last years at our center have been not taken over, but also are now discussed also at the normative order cluster in Frankfurt in a rather similar and very interesting direction. And as we have good contacts and a good exchange with the Frankfurt people, so to say, we are sure that we might profit from that from and in the direction of both sides. So I come to my next point, that is very shortly aesthetics, very shortly only. To deny the aesthetic dimension inherent to legal facts and dismiss it as legal style, the art of abstraction or analytical power, and to assume that law as a substantive power could subjugate the world through beautiful legal concepts alone would render law and the forces particularly closely linked to it, such as politics, with its proclivity, with its nearness to violence, all the more dangerous. Such a denial can make way for an aesthetization of law that masks power or even glorifies violence, and when taken to its extreme leads to fascism and totalitarianism. I could extend on that, but perhaps only one remark, short remarks on that. Our last year was devoted to deepening of these questions, in which 2 points should be reminded. On the one hand, we were wondering about the subjacent elective affinities of normative structures in the arts and in the legal sphere. Second, one still has to cope with a lot of prejudice concerning the aesthetic sphere in Germany, though especially centers for advanced studies in Nantes, in Marseille, develop more and more programs in order to bring the humanities, the social sciences, et les sciences dures more closely together with the arts. You come from Nantes and you had experience over there. As part of the evaluation committee of the French Centers for Advanced Study, I could observe last week in Marseille that currently at the IMERA, 3 fellows work with a double qualification in art and science. And we made a kind of a decision to exchange with them about their experience and our experiences. Well, looking at the 6th year, In a concluding phase that we are entering now, the research results of the 4 thematic pillars and their transversal linkages will be joined together again. The problem statement can be summed up as follows. What are the consequences of insights into the historically and culturally differentiated correlations between law and religion, the placement of law and competing normative orders in a multidimensional process of globalization, the fanning out of a legal culture's area of tension, and the many phases of legal representation in literature, film, and so forth. For the question, which importance is to be given to culture for the correct law, das richtige Recht? Does it constitute its own dimension of validity, eine eigene Geltungsdimension, empirically and perhaps also normatively? When particularly religiously defined communities demand the applicability of their legal culture within an applicable legal order, does this imply a shift from a long-gone system of justice dominated by classes to one dominated by culture, from a Klassenjustiz to a Kulturjustiz, as I called it some 25 years ago? This becomes especially clear when taking the example of the presence of Islamic law versus its different schools, or by way of its different schools of thought in Occidental societies on the one hand, but also in the multi-communitarian India. Within Europe, different legal cultural modes of transmitting differences in validity, Geltungsdifferenz, emerge. France is characterized by its model of laicism, which segregates the spheres of law and religion in the public space. In Germany, on the other hand, the reality of the state church is recognized. Our next book will speak about this relationship, and there should be a representation of that, but it is lacking. But it will come out in 2 weeks. In the Netherlands, the structural Versäulung, expanded by an additional Islamic pillar, is the subject of a tense debate on the limits of the traditional Dutch tolerance model. In Great Britain and Canada, finally, concepts of the transmission of particular cultures of validity and legal statal unity are undergoing rapid change. Does a sort of transcultural jurisprudence emerge from this tendency? How does the idea of legal universalism relate to a particular right to rights? What is the role of procedural culture in the opening of a discursive space in which different cultures' claim to validity can be articulated? Does culture become a source of law of sorts, in other words? Or does it not go beyond the symbolic legal decor, the outward appearance of legal practice, the observance of rituals, and the formal organizational guarantees of law? One may assume that the question as to the relationship between facts and norms, Faktizität und Geltung in Habermasian terms, cannot be dissociated from its cultural context. Likewise, the suspicion remains that an indiscriminate and to that extent culturalistic acceptance of the legal cultures misses insights into the value-bound character of supposedly purely formal legal cultures. So I come to the third point, from natural law to cultural law. You can feel completely relaxed. I won't be too long. Much shorter than the Massimo leader at Cuba, who became really in good shape after his third hour of a talk. Finally, some reflections should be devoted to the different fields of law. To what extent culture matters as an alternative argument to nature or history, tradition, and what kind of risk do we take when attributing this importance to culture? The question to be developed should be developed in much more in detail during the following period. Here I try to give some first ideas in the different fields of law. So I start with culture as an element of penal imputation, having written my dissertation about Durkheim's theory of punishment and crime. And this I may do in German. Would you really forgive me? I will try later on to translate it into French. That's more easier for me. In the English terms, it doesn't work because this has to do with the difference of legal cultures, because I had to transform it and to translate it into the common law tradition of understanding penal law. And I'm not so familiar with that. With the French, yes, but not so much with that. So, please forgive me. Auch wenn das Strafrecht und der Sinn des Strafens vom Geltungssinn her geprägt ist, das ist die große Einsicht von Günther Jacobs gewesen. Ich folge hier seiner kulturwissenschaftlichen Deutung der Strafrechtsdogmatik, die er in dem vielgerühmten Bändchen System der strafrechtlichen Zurechnung entwickelt hat. Also ein Geltungssinn, der in einem gesellschaftlich-kulturellen Kontext steht, sind in einer universalistisch angelegten Rechtskultur Grenzen dafür angelegt, diesen Geltungssinn zu unterlaufen. Du sollst das Tötungsverbot und die entsprechenden Tötungsdelikte lassen sich nicht durch einen Rechtfertigungsgrund der Eheverletzung so ohne weiteres relativieren. Das Cultural Defense Argument zieht nicht. Aber lässt sich auf der Tatbestandsebene, diejenigen, die mit dem Strafrecht vertraut sind, werden sich irgendwie noch erinnern, da gab es sowas, so einen 3-Stufen-Aufbau und so weiter, eine Art Kulturadäquanz postulieren. Ich bin ganz stolz, dass ich den Begriff heute früh erfunden habe. Und dann habe ich über Google, wir kennen das, die Strafrechtler kennen das als Sozialadäquanz. Ja? Also eine Übereinstimmung mit sozial geltenden Normen, die dazu führt, dass ein bestimmtes Verhalten schon aus der Tatbestandsmäßigkeit herausfällt. Ja? Also etwa bei der in der Beschneidungsdebatte ist das strafrechtlich argumentiert worden. Sozialadäquanz ist natürlich eine problematische Geschichte, auch weil man sich sozusagen anbindet an die Faktizität des Verhaltens. Aber man könnte in dem Sinne auch von Kulturadäquanz sprechen. Und dann habe ich einen Mitarbeiter, dem ich gerade da zufällig begegnet war, habe ich gefragt, Kulturadäquanz, kennst du das? Ja, doch, ist doch ganz verbreitet. Google-Test. Alles, was unter 1000 Hits ist in meiner Rechnung ein absoluter Begriffsbildungserfolg. Jedenfalls war es so, es waren nur irgendwie so 350 und nicht mehr. Und das ist bei Google schon ein sagenhaftes Ergebnis. Probieren Sie es mal mit Ihren eigenen begrifflichen Erfindungen. Also, das würde hier bedeuten, dass also in Ergänzung zu den Versuchen in dem körperverletzenden Eingriff der Beschneidung eine kulturell legitime Praxis von Geltungssinn der Strafnorm anzuschließen. Die familienrechtliche Auflösung des Konflikts ist einen anderen Weg gegangen, aber eine solche Interpretation lag in der Luft. Im System der strafrechtlichen Zurechnung im Sinne von Günther Jacobs wäre dies genau die Frage, ob die Tat einen kommunikativen Sinn enthält, der sich gegen die gesellschaftliche Vorstellung auflehnt, ihr den Geltungssinn abspricht oder aber gerade einen, wenn auch partikularen und dennoch mit anderen kulturell geteilten Geltungssinn als den richtigen unterstellt. Aber welche Relevanz hat das im Verhältnis zu einem staatlich formulierten Strafrecht? Und es bleibt spannend zu sehen, zu welchen Lösungen uns die soziologisch inspirierte vom kommunikativen Sinn des Handelns auf der einen Seite und der strafrechtlichen Reaktion hierauf argumentierenden Zurechnungslehre gerade für diesen Bereich noch führen mag. Ich komme zu einem anderen Punkt und das kriege ich vielleicht auch im Englischen so halbwegs hin. Family Law as Culture. During our common conference, Family Law as Culture, we still had a chance to discuss the role of culture as a constraint or as communalizing element in treating problems of family law in Europe. But has there been a shared conviction among the members of the Commission on European Family Law? One could interpret the aims and intentions of harmonization by that Commission as incompatible with the cultural bias assumption that anthropologists and sociologists and even the European Council proclaim when stating that family law is, I quote, very heavily influenced by the culture and tradition of national or even religious legal systems. which could create a number of difficulties in the context of harmonization. Masha Antokoloskaya has prominently argued against the so-called cultural constraint argument. It entails, as far as I see, two elements, her critique. On the one side, an empirically meant statement that family laws are embedded in different and unique cultural contexts factually, composed of heritage and traditions, and secondly, that these differences are unbridgeable and can neither spontaneously converge nor deliberately be harmonized. And this may be in the future a very important point for our discussions, I think in different fields of the law and legal orders. One has to go deeply into the legal culture debate, and we could do this with some of our wonderful colleagues, Friedman, David Nelken and others, who have done most impressive studies in the field. And we try to do it in our way. We don't have the time to revivify this debate in fast motion, but let me remind you of some of the arguments against the thesis of unique particularism. Cross-cutting affiliations simply go beyond the national borders, wherein a plurality of cultural orientations, such as the South and North dimension, for example, might prevail. Instead, progressive and conservative subcultures would have much more explanatory power, for example, in the acceptance of same-sex marriage patterns and divorce rules. Beyond those differences, on the progressive conservative scale, all-embracing European values would cut across the cultural constraint argument of unbridgeable diversity that is a kind of European family culture centered around individualism and rationalism, personalism and intellectualism, right consciousness and dissolution of traditional authority and respect for human rights, as the aforementioned Masha Antokoloskaya has formulated, in other words, patterns of modernity. Though the cultural constraint argument is refuted, the importance of a common culture, a pan-European culture at best embedded in human rights convictions, seems to be an underlying premise of the impressive work of the Commission on European Family Law. Once again, culture matters as a legal argument, but we do not get rid of all the methodological problems of how to interpret the laws or other normativities, but we have to ask more clearly, what does the reference to culture means when we try to find out the correct law, das richtige Recht? I come to an interlude, the critique of natural law by the historical school and the famous Methodenstreit. Not too long, but a part that seems to be necessary. The historical school had brought about a fundamental critique of the former natural law theory. Their preaching of Volksgeist left completely open and unresolved who was meant. The jurists are as bearers of judicial enlightenment or the people, creating a deepening gap between the people's law and the jurist's professional understanding of what the law is made of. In Max Ernst Mayer's differentiation of Rechtsnormen and Kulturnormen, the validity of especially the penal law is not bound to eternal imperatives, but to the conjunction of Rechtsnormen and those Kulturnormen that the individual does recognize. Underpinning the role of Geltung by Emil Lask, as our conference about the normative complex could show last year, leads in his famous student Gustav Radbruch to an understanding of Rechtswissenschaft als Kulturwissenschaft. Insofar as law interprets a wertbezogene Wirklichkeit, a term used by Heinrich Rickert, the Gewährsmann of Max Weber in matters of value theory. Berotzheimer, to be short in my excursion to the history of legal theory, is courageous enough to metamorphose the absolutely valid natural law into relative cultural law, relatives Kulturrecht, differing from positive law in a higher ranking normative order that is governed by legal principles embedded in the legal consciousness of the people. That is his solution. Turning to the vibrant methodological climate of Weimar, Erich Kaufmann too argued against the positivistic legend on the one side and the idea of an eternal natural law. Instead, each generation had to instill to those supposedly eternal principles its own spirit in order to create a proper cultural system. Ein eigenes Kultursystem von individueller Werthaftigkeit zu schaffen. Hermann Heller's methodological reflection still deserves some admiration when he formulates, and this really is a wonderful formulation, I think, die soziologische Deutung der geistigen Kulturgehalte versteht diese nicht immanent, sondern als eine Form, in der sich eine gesellschaftliche Wirklichkeit selbst auslegt. The law is an interpretation, a societal self-interpretation of its normativity. Rudolf Sment, finally, in interpreting the catalogue of fundamental rights as a Kultursystem, brings back a German tradition to conceive culture as the aim of the state. We are then in the Kulturstaats debate if we want to do that. So I had another point about constitutional cultures and the cultural reference of constitutional argumentation, and perhaps I just would like to hint at some elements of a debate where you can imagine that in constitutional law the reference to culture is very close. On the one side, whether there are rights to culture, and that we have the indigenous rights debate in the Colombian constitution, where is our co-worker from Colombia, he's not here. So, for example, this is one strong point in the debate. The other one is, of course, in how far cosmopolitan values, constructive consent, diversity of legal cultures find a place in international orders, as Martin Herdingen's last book, The Dynamics of International Law in a Globalized World, try to analyze in a very interesting way the question how human rights have to be interpreted as elements of constitutional law, and the tension on the one side of a cultural background, on the one side cultural derivations, the way cultural legitimizations on the one side, and the challenge to bring in universal norms to a world that cannot be debated, that are, as it was formulated in the declaration, in the French Declaration of Human Rights, as being sacred. That means untouchable. So this is a tension that still prevails, and there is, as far as I see, no general solution to this problematic, but it will be a question that you, for example, will discuss in the following weeks and months, and we are very, very keen and very interested to listen then to your explanations and explications. What, of course, may be a great problem is how and what kind of legal and normative cultures then will be in conflict. And it will be very often also a conflict between legal culture where a kind of collective identity is looked for on the one side, and that is perceived on the other side of being superimposed by an imperial power that just demands obedience and nothing else, as being just the state legal culture. And then in fact we come to a point of clash, and there is perhaps in advance no logical way to come out of this conflict. But of course, with reference to values like social order, we may try to show what it would mean if every community, every religious group would be able and would be given the right to not only develop but also to install, to institutionalize their specific values that might have a mutually excluding effect in social reality. So, of course, the image of cars is always painted for that, but we know countries like Brazil, India, and some others, perhaps also some African nations, where we might see that much more legal pluralism in this sense is possible, that, for example, is imaginable in the French context, where the idea of central normative power that runs through the veins of the whole society is prevailing and not allows for so much difference than other societies try to make possible. So this remains a debate, in this case linked to the question formally and from the argumentative point whether the cultural argument is a juristically relevant one and to what extent. So I come to my conclusion, as promised. I'm still 43 minutes. The provocative title of my talk, From Natural Law to Cultural Law, Changes of a Validity Culture, was meant to trace a trend of normative argumentation more than to denounce the factuality of cultural influences in the construction of normative orders. That would be ridiculous. Let me describe, however, a kind of a move from nature to history by way of the critique of the historical school, thereby proposing historicity as a criterion of the normative valid, and from there to culture as a point of reference in argumenting for a relatively valid historical and culturally bound law, or even the culture as the legitimate creator of new normative orders. The critique of a natural law type of legitimization is manifold. Factual diversity versus supposed eternity of the natural law. Projection of one's own political will into the mere form of natural law in the critique of natural law as an ideology, from Kelsen to Topic and others. The hiding of religious norms under the cover of eternity. Weber's differentiated analysis, we didn't have the time to go into that, but we can talk about this in the future, of the factual use of natural law arguments should not be forgotten, though in the debate about Naturrecht and materiale Gerechtigkeit, unfortunately, this contribution remained a little bit unperceived, too much. And that is why I had planned to remind all of you this forgotten debate now. But I won't have the time for that. That is why I go a little bit further to the real very end of the talk. With almost prophetic clairvoyance, Weber sees the consequences that result from the crisis of the dissolution of natural law that is promoted by legal rationalism itself as well as by modern intellectualism. I quote in German: Aber eben dieses Absterben seiner metajuristischen Verankerung gehörte zu denjenigen ideologischen Entwicklungen, welche zwar die Skepsis gegenüber der Würde der einzelnen Sätze der konkreten Rechtsordnung steigerten, eben dadurch aber die faktische Fügsamkeit in die nur noch utilitarisch gewertete Gewalt der jeweils sich als legitim gebarenden Mächte im Ganzen außerordentlich förderten. Punkt. Das ist schon this is even in German rather heavy, and in English it becomes awful. To such an extent, at least, that the rule of injustice during National Socialism has been traced back to the downfall of natural law, as some of you know, the debates after 45. This is something for which Weber would have presaged a sociological historical explanation. The normative weight of history bears apparently a close connection to the type of validity culture, as I call it. Common law traditions must attribute great authority to the historicity, something we find in religious law also, whether in Judaic legal cultures or in Islamic ones, where the binding force of a hadith is derived from the uninterrupted chain of narratives telling about the life of the Prophet and the telling that dispose of the antique power, according to the different legal cultures in Islam. Cultural study people have found the critical formula that must also be transferred to the normative complex, the danger of invented traditions that do exist. Culture, finally, is far from being innocent. It may claim for particular rights in a universalistic order. It may also hide the hidden political and economical interests behind. It is jurisdically not very precise, because the understanding of what counts a culture as culture is so broad and far from any kind of consensus. To make judgment no longer in the name of the law or in the name of the legal community, misleadingly still figuring as im Namen des Volkes, but referring to the explosive forces of culture, might lead to another kind of nightmare than the abuse of natural law in fascist systems or the reference to the past in a traditional validity culture. Let me close with a curious observation of a loop. Even when we are critical of natural law arguments, notwithstanding the impossibility to give a culture-free interpretation of the concept and the semantics of nature, this was always a problem in the natural law debate. The reference to the sphere of nature comes back in juristic argumentation. Suffering as the last resource of legitimizing human rights, as Upendra Bakshi had so powerfully shown, leads back to nature, the nature of the body. It is a body-related legitimacy of the human rights and of animal rights, pleading for a rational validity culture that tries to win its normative power from democratic procedures and the inherent values of a formal normative order, is confronted to a new function of legal cultures never thought of before, and this in a post-historic age, to foster and forge collective memory as a function of the law and processes, procedures, judgments, etc. And in the context of treating with atrocities, that this is very clear, but it goes beyond. And a further comeback cannot be denied: the urge to express one's identity, collective identity, not only in relation to a more or less glorious past, but also by way of the expression of a collective identity through the law, when the legal culture becomes the bearer of identity claims, going much beyond the narrow aim of eating halal or wearing a veil, but presenting normativity as a cultural trait of collective identity, a right to difference. The discourse about principles of normative validity has apparently not come to an end. The very old questions of nature, culture, and history still run through the veins of legal cultures who strive for, in an idealistic view, for the best solutions to normative problems that in the process of globalization are no longer separated and encapsulated in sharply divided legal spaces, but overlap, and plead for hybrid solutions where nature becomes historicized, culture related to nature, and history the playground for competing visions of culture and society. But whenever the idea of dual normative order is lacking, when the factual merges with the normativity, no higher values do exist than those that a poor reality offers to the makers of normativity. Then the dynamics of the normative complex are frozen to the facticity of normative banalities. This might be one important lesson for the reading of the so widespread cultures of injustice, where no criterion exists to question a law that is not only endowed with symbolic power, deontic force of the law and theoretical dynamics, but with the organizational power to enforce systematically the evil of injustice. That's all I have to say for the moment. Thank you very much for your interest.